It's customary to begin lectures on statutory interpretation with some thoughts on, well, I guess you could call the problem of interpretation. So here we go. Consider the following situation. Two men are running from the police. One is armed. The police are catching up with them. The man without the gun shouts at the armed man, "Let him have it, Chris." And Chris shoots the pursuing policeman dead. Those facts are, of course, based on those of Derek Bentley, a famous, possibly miscarriage of justice case. We're thinking about them because of the phrase, "Let him have it, Chris." Now, this phrase could be understood in two ways, couldn't it? It could be understood in terms of "let him have the gun, Chris," effectively surrender, give up the gun, or "let him have it," which means to shoot. Obviously, the man with the gun took it in that second sense. He shot and he tragically shot one of his pursuers dead. Now, if that's one of the examples of the ambiguities that are inherent in communication, then it's an example of an ambiguity that is inherent in oral communication. These problems that words carry different meanings are perhaps exacerbated in the example of written communication. And I think this area of communication, written communication, is the one that we're primarily concerned with. We are, of course, concerned with written legal communications, or, as the title of this lecture suggests, with statutory interpretation, with the interpretation of statute by judges. So all the problems that are inherent in that ambiguous statement, "Let him have it, Chris," which was oral, are, I think, 20-fold, if you like, in the example of written communication, when ultimately there's nobody there to explain. Now, if one thinks about the context of statutory rules or rules in statute, then we're concerned with a particular kind of written text, a legal text, with all the attendant problems of communication, given that we are talking about judges interpreting the words of the statutory draftsman. So to try and illustrate this problem, I want to talk about another famous example of the interpretation of language. Once again, this is drawn from Hart's book, The Concept of Law, and it concerns a famous rule. Let's say it's a statutory rule for the sake of our discussion so far, which says no vehicles in the park. Now let's imagine this is a very simple statute, an act of Parliament. And the rule in the statute that we have to interpret is just this: no vehicles in the park. It's a prohibition on vehicles in the park. Now we could say certain interpretations of this written rule are fairly straightforward. For instance, it is probably the case that a car is a vehicle, therefore it would not be difficult to agree that the rule "no vehicles in the park" prohibits cars from driving into the park. It's probably also a matter of agreement, let's say, that a bicycle ridden into the park may count as a vehicle, and therefore this rule prohibits bicycles being driven into the park. But there are other instances. Hart refers them to these instances as penumbral. The metaphor suggests things that fall into the shadow. In other words, so far we've been dealing with the core instances of the rule "no vehicles in the park," where we could say that the vehicle in question, a car, a bicycle, is clearly prohibited. What about somebody on roller skates, or a child in a pushchair, or a disabled person in a wheelchair, or even any other form of vehicle that you might want to think of? These are possibly penumbral instances. In other words, it's slightly more difficult to say whether, for example, somebody on roller skates counts as a vehicle. In other words, we're confronted with this issue of the interpretation of written rules. Now, I want to take a slight digression here and talk about, or draw our attention to a statement of Lord Bingham's in a case that we will look at a little bit later on, a case from 2003 called Quintervel. I want to draw attention, though, to the following paragraphs, which I think are useful for us because they allow us to engage with the problems around written statutory language and the problems of interpretation that they throw up. So here's a quotation from Lord Bingham, quote, "Such is the skill of parliamentary draftsmen that most statutory enactments are expressed in language which is clear and unambiguous and gives rise to no serious controversy. But these are not the provisions which reach the courts, or at any rate the appellate courts, where parties expend substantial resources arguing about the effects of a statutory provision. It is usually because the provision is, or is said to be, capable of bearing two or more different meanings, or to be of doubtful application to the particular case which has now arisen, perhaps because the statutory language is said to be inapt to apply to it, sometimes because the situation which has arisen is one in which the draftsman could not have foreseen and for which he has accordingly made no express provision. So what is Lord Bingham saying here? Well, we need to remember that the rules that we're thinking about are those in Acts of Parliament, which are of course drawn up by parliamentary draftspeople. Now, for the most part, Lord Bingham is saying that these rules are expressed in language which is clear and unambiguous and give rise to no serious controversy. So we could say that the work of the courts, the work of the judges on a daily basis involves the interpretation of statutory provisions, and these interpretations raise no problems, no ambiguities, no need to concern the court with the meaning of the words in the statutory enactment. However, Lord Bingham draws our attention to those provisions which do cause trouble. And he draws our attention to the reasons why certain statutory provisions may indeed be problematic. I mean, one has to remember that we are dealing with a court, with forensic argument, with arguments made on either side, so that will mean that people's lawyers are trying to exploit the ambiguities possibly in a statutory provision, and the judge is going to have to make a choice between those two rival interpretations. The other kind of factor that Lord Bingham suggests is important to bear in mind here is that certain statutory provisions may indeed be capable of bearing two or more different meanings. Now, an example of this is the word can in the Race Relations Act, which was interpreted in Mandler and Lee. Now, it's obviously a small word of the English language, the word can. The trouble was the word could be interpreted in one of two ways. One way would have destroyed the entire system of prohibition on race discrimination that the Act was trying to set up. So obviously a great deal was at stake in Mandler and Lee into how this word in the relevant Act could be interpreted. The issue that Lord Bingham also wants us to think about is possibly how a particular expression may raise the issue as to how it applies to a particular set of facts. For instance, in a case called Grant and South Western and County Properties Limited from 1975, Justice Walton had to decide whether a tape recording fell within the expression of the word document. He was interpreting the rules of the Supreme Court in this case. The judge in this case, Justice Walton, decided that the furnishing of information had to be treated as one of the main functions of a document, and he therefore concluded that a tape recording was indeed a document. So what Lord Bingham is asking us to think about are the various factors which come into play in statutory interpretation and the kind of instances that we find a court deliberating, troubling itself over the meaning of a word in a statute. Now, if you read into this area, you'll find that one way in which these issues of interpretation have been dealt with has been to say, well, there are different rules that have grown up over time, the so-called literal rule, the golden rule, and the mischief rule. Personally, I think this is somewhat misleading. These rules are of largely historical importance, and I don't think they really capture the way in which statutory interpretation takes place.